So how do we get to those constitutional problems? And this is where the INS v. Chadha case first comes in. So if you read through this case, you see it's an immigration case. It's not a war powers case, but it does have very important implications for the War Powers Act. As you read through that case, you'll see it's an immigration statute, and what the statute did was it allowed the Attorney General to suspend a deportation order for various reasons. But it provided a check on that suspension of a deportation order by the Attorney General by allowing either the House or the Senate effectively to veto the Attorney General's decision. So factually, we have this individual, Chadha. Chadha overstays his visa. He's deported. He goes through this process with the Attorney General's office, and the Attorney General believes that he satisfies all the criteria. The Attorney General suspends the deportation order, which would allow Chadha to remain in the country. But Chadha, along with some other individuals, this comes to the attention of some members of Congress. They introduce a resolution to veto the Attorney General's decision. And if you look at some of the procedural history, you'll see that it wasn't sort of hotly debated or anything like that. Very unlikely that many members paid much attention to it, but Congress approves this resolution, which has the legal effect under the statute of annulling the Attorney General's suspension of the deportation order. So effectively, it means Chadha will be deported. Chadha goes to court, challenges the constitutionality of the statute, and it goes up to the Supreme Court. So the issue before the Supreme Court is, does this congressional veto provision violate the constitutional separation of powers? And the majority opinion says, yes, it does. It violates the constitutional separation of powers. Now, a key issue kind of threading through this question is the existence of the modern administrative state. So we know we have a legislature, an executive, and a judiciary. Those are the three branches mentioned in the Constitution. But we know because of the size and the complexity of the modern administrative state that we have a vast administrative agency apparatus. And a great deal of that is within the executive branch. So how does that work? Well, the way it usually works is Congress adopts a statute that broadly sets up a regulatory scheme in a certain area and then delegates to usually an executive branch regulatory agency the authority to issue regulations and to administer those regulations consistent with the statute. And why do we do that? A number of reasons. I mean, think of something like the Federal Food and Drug Administration, the FDA. The FDA is a creature of the Federal Food, Drug, and Cosmetics Act. The Congress, enacts this statute that has to do with various things, including food and drug safety. But you don't want a committee of Congress deciding whether a particular pharmaceutical product is safe and effective for medical use. You want a body of experts making that decision. So Congress delegates to the FDA the ability to set up a mechanism where experts can actually look at that. If you take administrative law, there's lots and lots of issues that float around in there, and the extent to which an administrative agency is or is not acting consistent with the statute is an issue that often gets litigated. So there is this sense in which there's an issue of convenience or an issue of simply administrability that allows Congress to delegate these functions to administrative agencies. And in fact, Supreme Court precedent prior to Chadha had indicated that Congress has a very broad ability to delegate to executive agencies, and that remains the law. But the majority in Chadha says that is not enough to override a real problem with separation of powers. And in particular, the majority has two problems here. One is with the presentment clauses, and the other is with the bicameralism requirement. So the presentment clauses are in a number of places in the Constitution that indicate that the legislature adopts some legislation, and that must be presented to the executive, and the executive must approve it. And this is where the executive is able to veto legislation presented by Congress. Well, you kind of have the reverse situation here where the executive takes an action and the legislature has an opportunity to veto what the executive did. And the majority in Chadha said that's a real problem. That's unconstitutional. The only presentment and veto power is for the legislature to present to the executive. There's no presentment and veto power for the executive to present and the legislature to veto what the executive has done. The other piece of this is the bicameralism requirement. So the Constitution specifies that for legislation to be adopted, the House and the Senate, both chambers, vote on it and agree on it, and then present it to the executive, and then the executive approves it or vetoes it. So in this instance, the statute allowed either body, the House or the Senate, to adopt a resolution legislatively vetoing what the executive did. And in fact, factually, in Chadha's case, it was only a House resolution. So the majority says this is a problem, a number of structural problems with this statute. Nice little nugget from the majority opinion. The hydraulic pressure inherent within each of the separate branches to exceed the outer limits of its power, even to accomplish desirable objectives, must be resisted. So a very strong sense here that, yeah, there's a lot of tension, and when each branch has a certain responsibility, a lot of kind of temptation to overstep the constitutional bounds, but that those constitutional bounds have to be maintained. Justice Powell writes a concurrence, and what Justice Powell says is, yes, I agree with the result, but I'm really concerned with the reasoning because of the importance and breadth of the administrative state and the widespread use of legislative veto provisions in legislation that sets up administrative bodies to allow Congress to continue to have some check or control over this administrative operation. And so Powell says, I don't want to touch this in terms of the legislative veto issue. What I want to do is say it's really an Article 2 versus Article 3 issue. So the judicial function in Article 3 is to decide cases and controversies. Congress, the legislature, is not supposed to adjudicate individual cases. And so here, Justice Powell says, well, effectively what Congress did was they took Chadha's individual case. What the House did is took Chadha's individual case and adjudicated it. And that shouldn't happen. So Powell says, I would reach the same result, but I would do it under the judicial function issue so that I don't have to touch the whole administrative state. Now, Justice White goes even further and says, and dissents, and says this is really fundamentally important. There's many, many laws out there that, because of the way the administrative state functions, have legislative vetoes. And he mentions a number of them, but he does specifically mention among them the War Powers Act. And this is one reason why, a key reason why this case is important to us for our course right now, because he says, look, a number of statutes, including the War Powers Resolution, have legislative vetoes. And if the reasoning in Chadha is applied to those statutes would be held unconstitutional as well. And White thinks this is a bad idea because of the breadth of the administrative state. So given the majority's reasoning in Chadha, given what White says in his dissent, most scholars believe that if challenged, the War Powers Act probably would be held unconstitutional, that the ability of Congress to effectively veto an executive decision to commit military troops under the executive's authority as commander-in-chief in the Constitution would be a legislative veto that would violate Chadha. So very much in doubt whether the War Powers Act would even be effective. So Justice White also has a nice little quote where he talks about actually the convenience factor, while it can't fundamentally override the constitutional separation of powers, is really important, and we have to look at the reality of the administrative state. White, however, doesn't win the day in this particular case.